Good evening to all of you. Welcome to Legal Matters by Sai Babu Sankara. So, once again, we are going to discuss the delay. In this in this video, we are going to discuss Honorable Supreme Court's direction that the convicts who have completed 10 years of period in jail, they can be released on bail. The convicts who have completed 14 years of jail period, they can be actually thought of going out on the so-called premature release. That is release on the occasion of the so-called presently we are doing August 15th and Mahatma Gandhi birthday October 2nd and all these things. Right. 10 years release, 14 years premature release. So Azadi Ka Amrit Mahotsav. In such occasions they can be released. Why this thing? The main reason is the appeals are not being heard. The appeals are being kept pending. It is surprising to note that, of course, as advocates we know, but general people they don't know. They will be really surprised if they come to know that a case of 1996, an appeal of 1996 sent from the Sessions Court, Ongole, is still pending in the Honorable High Court of Andhra Pradesh. When Honorable Justice Manmadh Rao Garu came to Ongole, this was expressed or this was told to him by the Bar Association of Ongole. It's there on record, 1996 matter. So many appeals, they have been pending before the High Courts, they have been pending before the Supreme Court also. So the cases are not being proceeded with. The persons are languishing in jail. So what to do? Hussainara Khatun, you may be knowing that case. So unnecessarily the persons should not be detained. Right, now let us go to the case. Justice Sanjay Kishan Kaul and Abhay Srinivasa Oka, while considering a batch of petitions of the life convicts in jail whose appeals are pending in various high courts. You can see the case as Sonadhar Vs State of Chattisgarh in SLP number 529 by 2021, and the decision came yesterday, 15/9/2022. In this connection, the Supreme Court directed that the convicts who have completed 10 years of jail, 10 years of sentence, they can be released on bail. And the appeals, please remember, because whose appeals are not heard over, this is important, they may be released on bail. And if it is 14 years, they may be thought of going out on the so-called premature release. Right. In this connection, actually, Shri Advocate Gaurav Agarwal, he was actually appointed as the Amicus Curie. You may be knowing who is Amicus Curie. Who is Amicus Curie? Huh? Yes. He is the friend of the court. Amicus Curie is a judge or is an advocate who assists the court, because court cannot go to each and every place. Anagada. ప్రతి వెళ్ళలేదు కదా కోర్టు, అందుకని చెప్పి ఎస్ ది కోర్ట్ విల్ అపాయింట్ certain advocates as amicus curie. And actually this amicus curie, he has addressed 6 high courts regarding, has done exercise regarding identifying the life sentence convicts. So please remember, 2 types of convicts who have completed 10 years and convicts who have been completed 14 years. These 2 categories have come. Ultimately, to his knowledge, 5,740 appeals are pending. So in these 6 high courts, for example, Bihar, it has got 268 convicts and their cases are being taken up for premature release. So Orissa and Allahabad High Court, 385 convicts, they are strangling or they are being incarcerated jail for the last 14 years. So now the time has come for the Honorable Supreme Court of India for decluttering, right? With the aim of or with the object of decluttering the jails, the above exercise is undertaken, and the other high courts also, they have to reply on urgent basis. So please remember, number 1, 3 points are necessary in this judgment. Number 1, the appeals are kept pending. Appeals are not likely to be decided in the future 1 or 2 years. In such cases, If the convicts have served a sentence of more than 10 years, they may be thought of getting out on bail. If they have completed 14 years of incarceration, they may be thought of getting out on a premature release. So please remember, directions were given to Patna High Court also, Bihar High Court. Since I have got 268 convicts, actually it is on pari materia basis. That means acts involving both. If the two acts are on the same point, it is called pari materia. I have told you in the interpretation clauses also. So directions are to Patna High Court in pari materia basis, and even to the other high courts also. So you have to take into consideration, if the persons completed 10 years, they may be thought of getting on bail because the appeals are not being heard in the nearest possible time. Likewise, when they have completed 14 years, already you know section 31 CRPC. In any case, the life sentence is also equal to 14 years. So in such a case, they may be thought of getting out on premature release. Good decision by the Honorable Supreme Court of India. So please read it and enrich with your legal knowledge. Thank you very much.